Q90. What are the requisites of judicial review? 1. Actual case or controversy. 2. It must be raised by a proper party. 3. It must be raised at the earliest proper opportunity. 4. It must be necessary to the determination of the case. Q91. What are the exceptions to mootness? A. There is a grave violation of the Constitution. B. The exceptional character of the situation and the paramount public interest is involved. C. When the constitutional issue raised requires formulation of controlling principles to guide the bench, the bar, and the public. D. The case is capable of repetition, yet evading review. David versus Arroyo. 92. What is the concept of rotational scheme of appointment? The concept is intended to prevent any incumbent president to appoint majority of the member of the Constitutional Commission. To achieve this end, the following must concur. The term of the first commissioner should start on a common date. Any vacancy before expiration should be filled only for the unexpired balance. Gaminde versus COA, December 13, 2000. 93. What is the rule on rotational scheme of appointment in the Constitutional Commission? The appointment of members of any of the three constitutional commissions after the expiration of the uneven terms of office of the first set of commissioners shall always be for a fixed term of 7 years. An appointment for a lesser period is void and unconstitutional. The appointing authority cannot validly shorten the full term of 7 years in case of the expiration of the term, as this will result in the distortion of the rotational system prescribed by the Constitution. B. Appointments to vacancies resulting from certain causes, death, resignation, disability, or impeachment, shall only for the unexpired portion of the term of the predecessor, but such appointments cannot be less than the expired portion, as this will likewise disrupt the staggering of terms laid down under Section 1, Number 2 of Article 9, letter D. C. Members of the Commission, that is COA, Comelec, or CSC, who were appointed for a full term of 7 years and who served the entire period, are barred from reappointment to any position in the Commission. Corollarily, the first appointees in the Commission under the Constitution are also covered by the prohibition against reappointment. D. A commissioner who resigns after serving in the Commission for less than 7 years is eligible for an appointment to the position of chairman for the unexpired portion of the term of the departing chairman. Such appointment is not covered by the ban on reappointment, provided that the aggregate period of the length of service as commissioner and the unexpired portion of the term of the predecessor will not exceed 7 years, and provided further that the vacancy in the position of chairman resulted from death, resignation, disability, or removal by impeachment. E. The court clarifies that reappointment found in Section 1, Number 2, Article 9, letter D, means a movement to one and the same office, like commissioner to commissioner or chairman to chairman. On the other hand, an appointment involving a movement to a different position or office, commissioner to chairman, would constitute a new appointment and hence not in a strict legal sense a reappointment barred under the Constitution. Funa versus Villar. 94. What is the jurisdiction of the Comelec over election contests? Exercise exclusive original jurisdiction over all contests relating to the elections, returns, and qualifications of all elective regional, provincial, and city officials, and appellate jurisdiction over all contests involving elective municipal officials decided by trial courts of general jurisdiction, or involving elective barangay officials decided by trial courts of limited jurisdiction. 95. Who has jurisdiction over the qualifications of party lists, Comelec or HRET? The Comelec has jurisdiction. However, with respect to the qualification of the nominees of party list, it is the HRET which has jurisdiction. Laig versus Comelec, February 28, 2012. 96. Does the Comelec have jurisdiction over exclusion or inclusion of voters? No. Under Section 3, Article 9, letter D, the Comelec can decide all questions relating to election except the right to vote. 97. What are the territorial and political of the Philippines? The territorial and political subdivisions of the Republic of the Philippines are the provinces, cities, municipalities, and barangays. There shall be autonomous regions in Muslim Mindanao and the Cordilleras as hereinafter provided, Section 1, Article 10. 98. Can Congress pass a law creating an autonomous region in Southern Tagalog? No. Under Section 1, Article 10, autonomous regions can only be established in Muslim Mindanao and Cordilleras. 99. What are the requisites for a valid ordinance? The following are the requisites for a valid ordinance. 1. It must not be contrary to the Constitution or law. 2. It must not be unfair or oppressive. 3. It must not be partial or discriminatory. 4. It must not prohibit but regulate trade. 5. It must not be unreasonable. 100. What is the nature of the taxing power of local government units? It is a constitutional grant. Section 5, Article 10 provides, each local government unit shall have the power to create its own sources of revenues and to levy taxes, fees, and charges subject to such guidelines and limitations as the Congress may provide, consistent with the basic policy of local autonomy. Such taxes, fees, and charges shall accrue exclusively to the local governments. Thus, Congress cannot deprive LGU of its power to tax. It can only regulate the same. 101. May the power of local governments to raise revenues be limited to administrative order? Under Section 5, Article 10, only guidelines and limitations that may be established by Congress can define and limit such power of local governments. John Hay v. Lim. 102. May Congress impose conditions for the release of IRA? No. It is prescribed by Section 6, Article 10, which provides that local government units shall have a just share, as determined by law, in the national taxes which shall be automatically released to them. Batangas v. Executive Secretary. 103. Article 10, Section 6 of the Constitution provides that local government units shall have a just share as determined by law in the national taxes which shall be automatically released to them. Under Section 284 of the LCG, Section 284, allotment of internal revenue taxes, local government units shall have a share in the national internal revenue taxes based on the collection of the third fiscal year preceding the current fiscal. Should the IRA be limited to national internal revenue taxes? No. Although the power of Congress to make laws is plenary in nature, congressional lawmaking remains subject to the limitations stated in the 1987 Constitution. The phrase national internal revenue taxes engrafted in Section 284 is undoubtedly more restrictive than the term national taxes written in Section 6. As such, Congress has actually departed from the letter of the 1987 Constitution, stating that national taxes should be the base from which the just share of the LGU comes. Such departure is impermissible. Verba legis non est recedendum. From the words of a statute, there should be no departure. Equally impermissible is that Congress has also thereby curtailed the guarantee of fiscal autonomy in favor of the LGUs under the 1987 Constitution. Customs duties are also taxes because they are exactions whose proceeds become public funds. According to Garcia v. Executive Secretary, custom duties is the nomenclature given to taxes imposed on the importation and exportation of commodities and merchandise to or from a foreign country. Mandanas v. Executive Secretary, GR number 199802, July 3, 2018. 104. What is the term of local government elective officials? The term of office of elective local officials, except barangay officials, which shall be determined by law, shall be 3 years, and no such official shall serve for more than 3 consecutive terms. voluntary renunciation of the office for any length of time shall not be considered as an interruption of the continuity of his service for the full term of which he was elected. Section 8, Article 10. 105. When will the three-term limit of local elective officials apply? Two requisites must concur. 1. Official must have been elected to the same position 3 times. 2. He must have served 3 full terms. 106. What are the rules on terms limits of local government elective officials? When a permanent vacancy occurs in an elective position, and the official merely assumed the position pursuant to the rules and succession under the LGC, then his service for the unexpired portion of the term of the replaced official cannot be treated as one full term, as contemplated under the subject constitutional and statutory provisions. That service cannot be counted in the application of any term limit. Borja Jr. versus Comelec. B. If the official runs again for the same position he held prior to his assumption of the higher office, then his succession to said position is by operation of law and considered an involuntary severance or interruption. Monty Bourne versus Comelec. C. An elective official who has served for 3 consecutive terms and who did not seek the elective position for what could be his 4th term, but later won in a recall election, had an interruption in the continuity of the official's service, for he had become, in the interim, that is, from the end of the 3rd term up to the recall election, a private citizen. Adormeo versus Comelec. Socrates versus Comelec. D. The abolition of an elective local office due to the conversion of a municipality to a city does not by itself work to interrupt the incumbent official's continuity of service. La Tasa versus Comelec. E. Preventive suspension is not a term-interrupting event, as the elective officer's continued stay and entitlement to the office remain unaffected during the period of suspension, although he is barred from exercising the functions of his office during this period. Aldovino Jr. versus Comelec, 2009. F. When a candidate is proclaimed as winner for an elective position and assume office, his term is interrupted when he loses in an election protest and is ousted from office, thus disenabling him from serving what would otherwise be the unexpired portion of his term of office had the protest been dismissed. Loncenida versus Comelec. G. The break or interruption need not be for a full term of 3 years or for the major part of the 3-year term. An interruption for any length of time, provided the cause is involuntary, is sufficient to break the continuity of service. Socrates versus Comelec. H. When an official is defeated in an election protest and said decision becomes final after said official had served the full term of said office, then his loss in the election contest does not constitute an interruption, since he has managed to serve the term from start to finish. His full service despite the defeat should be counted in the application of term limits because the nullification of his proclamation came after the expiration of the term. Ong versus Alegre. I. A winner who dislodges in a recall election an incumbent elective local official merely served the balance of the latter's term of office. It is not a full 3-year term. It also goes without saying that an incumbent elective local official against whom a recall election is initiated, and who nevertheless wins in a recall election, must be viewed as being a continuing term of office and not as a break in reckoning 3 consecutive terms. A recall election term, then, not being a full 3-year term, is not to be counted or used as a basis for disqualification, whether it is held prior or subsequent to the 9-year full 3-term limit. Mendoza versus Comelec, 2013. 107. Article 10, Section 10 provides, no province, city, municipality, or barangay may be created, divided, merged, abolished, or its boundaries substantially altered, except in accordance with the criteria established in the local government code and subject to approval by a majority of the votes cast in a plebiscite in the political units directly affected. who should participate in the plebiscite? The voters of the unit or units directly affected. Tan versus Comelec. 108. Cabanatuan City, by virtue of the EO issued by the President, was converted to a highly urbanized city. The issue is, who should participate in the plebiscite? The registered voters of the Cabanatuan City or the whole registered voters of the province of Nueva Ecija? The whole province of Nueva Ecija, in interpreting the phrase subject to approval by a majority of the votes cast in a plebiscite in the political units directly affected under Section 10, Article 10, the Supreme Court ruled that the province of Nueva Ecija will be directly affected by the conversion of Cabanatuan City to highly urbanized city. The province of Nueva Ecija will be impacted economically and politically. Economically, because Cabanatuan City will be segregated from the province of Nueva Ecija. Thus, the territory of the Nueva Ecija will be substantially reduced. Consequently, the era that is allotted to Nueva Ecija will also be reduced. The province will also lose income from the conversion, as the taxes of the highly urbanized city will accrue exclusively to the highly urbanized city. Politically, province of Nueva Ecija will also be impacted. Duties, privileges, and obligations appertaining to highly urbanized cities will attach to Cabanatuan City if it is converted into an highly urbanized city. This includes the right to be outside the general supervision of the province and be under the direct supervision of the President. An HUC is not subject to provincial oversight because the complex and varied problems in an HUC due to a bigger population and greater economy activity requires greater autonomy. The provincial government stands to lose the power to ensure that the local government officials of Cabanatuan City act without the scope of its prescribed powers and functions, to review executive orders issued by the city mayor, and to approve resolutions and ordinances enacted by the city council. The province will also be divested of jurisdiction over disciplinary cases concerning the elected city officials of the new highly urbanized city, or HUC, and the appeal process for administrative case decisions against barangay officials of the city will also be modified accordingly. Likewise, the registered voters of the city will no longer be entitled to vote for and be voted upon as provincial officials. Umali versus Comelec, 2014. 109. Who are the impeachable officers? The following are the impeachable officers. 1. President. 2. Vice President. 3. Chief Justice of the SC, Supreme Court, and its justices. 4. Chairman and Commissioners of the Constitutional Commissions. 5. Ombudsman. 110. What are the grounds for impeachment? Culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of public trust. Article 11, Section 2. 111. What is the procedure for impeachment? First, a verified complaint for impeachment must be filed by any member of the House of Representatives or by any citizen upon a resolution of endorsement by any member. Second, included in the order of business within 10 days, 10 session days, and referred to proper committee within 3 session days. Third, the committee, upon majority vote of all its members, shall submit its report, which should be done within 60 days after referral. Fourth, if the verified complaint is filed by at least 1/3 of all the members of the House, the same shall constitute the articles of impeachment. Fifth, a vote of at least 1/3 of all the members of the House shall be necessary either to affirm a favorable resolution or override its contrary resolution. 112. No impeachment proceedings shall be initiated against the same official more than once within a period of 1 year. What is meant by initiation? The Supreme Court gives the term initiate different from filing. The impeachment is deemed initiated when the complaint with accompanying resolution of endorsement has been filed with the House of Representatives and referred to appropriate committee, Francisco Riz's House of Representatives. 113. Can there be multiple grounds in an impeachment complaint? Gutierrez versus House of Representatives, February 25, 2011, rules that an impeachment complaint need not allege only one impeachable offense. In fact, multiple complaints may be considered so long as they would all be simultaneously referred or endorsed to the proper committee. What is Regalian Doctrine? 114. All lands are owned by the Crown. This is reflected in the 1987 Constitution. Thus, all lands of the public domain, waters, minerals, coal, petroleum, and other mineral oils, all sources of potential energy, fisheries, forests or timber, wildlife, flora and fauna, and other natural resources are owned by the state. 115. What is the consequence of the Regalian Doctrine? The exploration, development, and utilization (EDU) of natural resources shall be under the full control and supervision of the state, and a person claiming ownership of a portion of the public domain must be able to show title from the state according to any of the recognized modes of acquisition of title. 116. If a person is the owner of agricultural land in which minerals are discovered, does this ownership of such land give him the right to extract or utilize the said minerals without the permission of the state? No. The minerals are owned by the state under the Regalian Doctrine. The land is thus converted into mineral land. For the loss sustained by the owner, he is entitled to compensation. Republic versus CA. 117. Are there lands which are not covered by Regalian Doctrine? Yes. When as far back as testimony or memory goes, the land has been held by individuals under a claim of private ownership, it will be presumed that to have been held in the same way from before the Spanish conquest and never to have been public land. Carreño versus Insurer. 41 Phil 935. Cruz versus DNR. 118. Who are qualified to take part with the state in the exploration, development, and utilization of natural resources? The state may enter into co-production, joint venture, or production sharing agreement with Filipino citizens or corporations, associations, at least 60% of whose capital is owned by Filipino citizens. 119. May foreign corporations participate in the EDU of mineral resources? Yes. The President may enter into agreements with foreign-owned corporations involving either technical or financial assistance for large-scale EDU of mineral, petroleum, and other mineral oils. Section 2. 120. When husband and wife purport to buy land, and the husband is alien while the wife is Filipino, is the property conjugal such that it may not be disposed of without the consent of the husband? The property cannot be deemed conjugal because of the incapability of the alien husband to own private land. Thus, the alien husband has no capacity to question the sale made by the Filipino wife. Cheeseman versus IAC. 121. May a Filipino seller question the legality of sale he made in favor of an alien? Will pari delicto apply? The seller may question the sale made to the alien. The principle of pari delicto is not applicable. Philippine Banking Corporation versus Louis Shi. 122. Section 11, Article 12 provides, no franchise, certificate, or any other forms of authorization for the operation of a public utility shall be granted except to citizens of the Philippines or to corporations or associations organized under the laws of the Philippines, at least 60% of whose capital is owned by such citizens, nor such franchise, certificate, or authorization be exclusive in character for a longer period than 50 years. What is the meaning of 60% capital ownership? Mere legal title is insufficient to meet the 60% Filipino-owned capital required in the Constitution. Full beneficial ownership of 60% of the outstanding capital stock, coupled with 60% of the voting rights, is required. The legal and beneficial ownership of 60% of the outstanding capital stock must rest in the hands of Filipino nationals in accordance with the constitutional mandate. Otherwise, the corporation is considered as non-Philippine nationals. Gamboa versus Finance Secretary. Since the Constitution requirement of at least 60% Filipino ownership applies not only to voting control of the corporation, but also to the beneficial ownership of the corporation. It is therefore imperative that such requirement apply uniformly and across the board of all classes of shares, regardless of nomenclature and category, comprising the capital of a corporation. Under the Corporation Code, capital stock consists of all classes of shares issued to stockholders, that is, common shares as well as preferred shares, which may have different rights, privileges, or restrictions as stated in the Articles of Incorporation. Q123. Does the Commission on Human Rights enjoy fiscal autonomy? It enjoys fiscal autonomy only to the extent that its appropriation shall be automatically regularly released. CHR Employees Association versus CHR. 124. Does CHR have jurisdiction over cases involving socio-economic rights? No. The Constitution provides that the CHR has the power to investigate on its own or on complaint by any party all forms of human rights violations involving civil and political rights. Section 18. Article 13. Simon Jr. versus CHR. 125. What is police power? It is the power of the state to regulate liberty and property for the common good, the power of promoting the public welfare by restraining the use of liberty and property. 126. May the power of eminent domain be used as an implement of police power? Give example. To the extent that the measures under challenge merely prescribe pretension limits for landowners, there is an exercise of the police power for the regulation of private property in accordance with the Constitution. But where to carry out such regulation, it becomes necessary to deprive such owners of whatever lands they may own in excess of the maximum area allowed. There is definitely a taking under the power of eminent domain for which payments of just compensation is imperative. Association of Small Landowners versus DAR. 127. What power is implemented in giving senior citizens discount of 20%? Police power. Manila Memorial Park versus Secretary. 128. What are the two tasks to determine the validity of the exercise of police power? Lawful subject. The interests of the public, generally as distinguished from those of a particular class, require the exercise of police power. Lawful means. The means employed or reasonably necessary for the accomplishment of the purpose and must not be unduly oppressive. 129. LGU passed an ordinance levying a special assessment equivalent to 0.5% of the assessed value of land in excess of 100,000 pesos shall be collected by the city treasurer, which shall accrue to the socialized housing programs of the Quezon City government. The special assessment shall accrue to the general fund under a special account to be established for the purpose. The fund will be used for the benefit of informal settlers. Petitioners question the constitutionality of the ordinance on the ground that people should not be required to pay for the services that the government is mandated to do. Further, it is a form of class legislation since it favors informal settlers who occupy property not their own and pay no taxes over law-abiding real property owners who pay income and realty taxes. Is the ordinance constitutional? Yes. Section 6, Article 12 provides that the use of property bears a social function and all economic agents shall contribute to the common good. Individuals and private groups, including corporations, cooperatives, and similar collective organizations, shall have the right to own, establish, and operate economic enterprises, subject to the duty of the state to promote distributive justice and to intervene when the common good so demands. Property rights of individuals may be subjected to restraints and burdens in order to fulfill the objectives of the government in the exercise of police power. In this jurisdiction, it is well entrenched that taxation may be made to implement the state's police power. Fur versus Bautista. 130. A law is passed requiring to also publish information as to the name of the person, candidate, party, or organization who commissioned or paid for the survey. Is the law valid? We sustain the validity of Resolution number 9674. The names of those who commissioned or paid for election surveys, including subscribers of Survey firms must be disclosed pursuant to Section 5.2, letter A of the Fair Election Act. This requirement is a valid regulation in the exercise of police power and affects the constitutional policy of guaranteeing equal access to opportunities for public service. Section 5.2, letter A's requirement of disclosing subscribers neither curtails petitioners' free speech rights nor violates the constitutional proscription against the impairment of contracts. SWS versus Comelec. 131. Is survey and election propaganda? Yes. The inclusion of election surveys in the list of items regulated by the Fair Election Act is a recognition that election surveys are not a mere descriptive aggregation of data. Publishing surveys are a means to shape the preference of voters, inform the strategy of campaign machineries, and ultimately affect the outcome of elections. Election surveys have a similar nature as election propaganda. They are expensive, normally paid for by those interested in the outcome of the elections, and have tremendous consequences on election results. 132. What is the power of eminent domain? The power to take private property for public use upon payment of just compensation. 133. What is the remedy of the landowner if the government refused to pay the just compensation? If after 5 years after the finality of judgment in an expropriation proceeding, the government failed to pay the just compensation, the landowner has the right to file an action for the recovery of possession of the property. Republic versus Lien. 134. Who has the authority to determine just compensation? It is the court, EPSA versus Tulay. Legislative enactments as well as executive issuances fixing the method of computing just compensation are tantamount to impermissible encroachment on judicial prerogatives. MPC versus Spouses Sabala and Ililia Bailon. 135. The Congress passed a law providing for a formula by which the court can compute the amount of just compensation. Is the court bound by the formula? The LBP correctly argued that consideration of the evaluation factors under Section 17 of RA 6657 and the formula under DAR AO number 059835 is mandatory in ascertaining just compensation for purposes of agrarian reform cases. In Land Bank of the Philippines versus Gonzales, we held that although the determination of just compensation is fundamentally a judicial function vested in the RTC, the judge must still exercise his discretion within the bounds of law. He ought to take into full consideration the factors specifically identified in RA 6657 and its implementing rules, as contained under the pertinent administrative order of DAR, such as DAR AO number 598, which contains the basic formula of the factor enumerated under said law. He may not disregard the procedure laid down therein, because unless an administrative order is declared invalid, courts have no option but to apply it. Otherwise, the judges runs the risk of violating the agrarian reform law should he choose not to use the formula laid down by the DAR for the determination of just compensation. The court reaffirmed this established jurisprudential rule in Alfonso versus Land Bank of the Philippines when it categorically gave full constitutional presumptive weight and credit to Section 17 of RA 6657. DAR number 5, 1998, and the resulting DAR basic formulas, LDP versus Spouses Esteban, 2017. 136. What are the two aspects of due process? Substantive due process and procedural due process. 137. What are the requisites of substantive due process? First, the interest of the public in general, as distinguished from a particular class, requires the intervention of the state. Second, the means employed are reasonably necessary for the accomplishment of the purpose and must not be duly oppressive. When does life begins? Life commences upon conception, that is, upon fertilization. When the egg cell and sperms meet, then their life begins. Hence, the obligation upon the state to equally protect the life of the mother and the life of an unborn from conception prevents the legislature from legalizing abortion. Imbong versus Ochoa. In a preliminary investigation, is the respondent entitled to be furnished of copies of the counter affidavit of their correspondents? No, there is no law or rule which requires the investigating prosecutor to furnish a respondent with copies of the counter affidavits of his correspondents. The rights of a respondent in a preliminary investigation are limited to those granted by procedural law. The rights conferred upon accused persons to participate in preliminary investigations concerning themselves depend upon the provisions of law by which such rights are specifically secured rather than upon the phrase due process of law. Estrada versus Ombudsman. Is administrative due process applicable in preliminary investigation? No. This is because a preliminary investigation is not a quasi-judicial proceeding, since the prosecutor in a preliminary does not determine the guilt or innocence of the respondent. Same case. What is Equal Protection Clause? All persons or things similarly situated shall be treated alike, both as to the rights conferred and responsibilities imposed. Inchang versus Hernandez. What are the requirements of valid classification? It must be based on substantial distinction. It must be germane to the purpose of law. It must not be limited to existing conditions. It must apply equally to all members of the same class. Section 47 of RA 8791, otherwise known as the General Banking Law of 2000, which took effect on June 13, 2000, amended Act No. 3135. The law provides, notwithstanding Act 3135, juridical persons whose property is being sold pursuant to an extrajudicial foreclosure shall have the right to redeem the property in accordance with this provision until, but not after, the registration of the certificate of foreclosure sale with the applicable register of deeds, which in no case shall be more than 3 months after foreclosure, whichever is earlier. Owners of property that has been sold in a foreclosure sale prior to the effectivity of this act shall retain their redemption rights until their expiration. Is the law valid? The difference in the treatment of juridical persons and natural persons was based on the nature of the properties foreclosed, whether these are used as residence, for which the more liberal 1-year redemption period is retained, or used for industrial or commercial purposes, in which case a shorter term is deemed necessary to reduce the period of uncertainty in the ownership of property and enable mortgagee banks to dispose sooner of these required assets. It must be underscored that the General Banking Law of 2000, crafted in the aftermath of the 1997 Southeast Asian financial crisis, sought to reform the General Banking Act of 1949 by fashioning a legal framework for maintaining a safe and sound banking system. In this context, the amendment introduced by Section 47 embodied one of such safe and sound practices aimed at ensuring the solvency and liquidity of our banks. It cannot therefore be disputed that the said provision amending the redemption period in Act 3135 was based on a reasonable classification and germane to the purpose of the law. Golden Way Merchandising Corporation versus Equitable PCI, March 13, 2013. Can Congress reenact a law which was already declared by the Supreme Court unconstitutional? No. Thus, when a law or a provision of law is null, because it is inconsistent with the Constitution, the nullity cannot be cured by reincorporation or reenactment of the same, or a similar law or provision. A law or provision of law that was already declared unconstitutional remains as such unless circumstances have so changed as to warrant a reverse conclusion. Samiro versus Placement Agency versus Cabiles. Can Section 2, Article 3 be invoked against Barangay Tanod? The Barangay Tanod was considered as agent of person in authority under Article 388 of the Local Government Code. Hence, they are not considered to be private individuals. Del Castillo versus People. How is probable cause determined in the issuance of search warrant? It is determined by personally examining in the form of searching questions and answer, in writing and under oath, the complainant and the witnesses he may produce on facts personally known to them. Section 5, Rule 126. How is probable cause determined in the issuance of warrant of arrest? It can be determined on the basis of the personal examination of the judge of the report and the supporting documents submitted by the prosecutor. The judge issued warrant when what was submitted was only the resolution of the investigating prosecutor and affidavits of the complainant. The prosecutor did not attach copies of the affidavit of the witnesses for the complainant and the counter affidavit of the respondent. Is the judge correct? No, because it was not the judge who determined probable cause, but the prosecutor, because the judge relied only to the finding of probable cause by the prosecutor. Okabe versus Judge Gutierrez. In restricting or blocking access to computer data, when a computer data is prima facie found to be in violation of the provisions of this Act, the DOJ shall issue an order to restrict or block access to such computer data. Section 19 RA 10175, Cybercrime Law. Is this constitutional? No. Government, in effect, seizes and places the computer data under its control and disposition without warrant. DOJ order cannot substitute judicial warrant. Disney versus ES. What are the exceptions to arrest with warrant? When in his presence the person to be arrested has committed or actually committing or is attempting to commit an offense. When an offense has just been committed and he has probable cause to believe that, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it, and when the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment, or is temporarily confined while his care is pending, or has escaped while being transferred from one confinement to another. What are the elements of arrest in flagrante delicto? The person to be arrested must execute an overt act indicating that he had just committed, is actually committing, or is attempting to commit. Such overt act is done within the view of the arresting officer. Antiquera versus People. What are the requisites of plain view? The law enforcement officer in search of the evidence has a prior justification for an intrusion or is in a position from which he can view a particular area. B. The discovery of the evidence in plain view is inadvertent, and it is immediately apparent to the officer that the item he observes may be evidence of a crime, contraband, or otherwise subject to seizure. People versus Chi Chen Lu, 2015. The accused was driving a motorcycle without a helmet in violation of a traffic ordinance. The police officer arrested the accused and searched his pocket, finding a sachet of shabu. Is the sachet of shabu admissible in evidence? No. A person caught for a traffic violation should not be arrested. He should only be issued a citation ticket. Thus, if he should be arrested for violation of traffic ordinance, then his arrest is invalid. Consequently, the evidence obtained as a result of an illegal arrest is inadmissible in evidence. Luce versus People, February 29, 2012. What is a right to privacy? It is the right to be free from unwarranted exploitation of one's person or from intrusion into one's private activities in such a way as to cause humiliation to a person's sensibilities. Social Justice Society versus DBB. What are the two tasks in determining whether one is entitled to the right of privacy? In determining whether or not a matter is entitled to the right to privacy, this court has laid down a twofold test. The first is a subjective test, where one claiming the right must have an actual or legitimate expectation of privacy over a certain matter. The second is an objective test, where his or her expectation of privacy must be one society is prepared to accept as objectively reasonable. Disney versus ES. Angela Tan, a high school student at St. Teresa College, uploaded on Facebook several pictures of her and her classmates, Nenita Dalus and Julianne Suzara, wearing only their undergarments. Thereafter, some of their classmates reported said photos to their teacher, Mylene Escudero. Escudero, through her students, viewed and downloaded said pictures. They showed the said pictures to STC's discipline in charge for appropriate action. Is the right of the children to privacy violated? Before one can have an expectation of privacy in his or her online social networking activity, it is first necessary that said user, in this case the children of petitioners, manifests the intention to keep certain posts private through the employment of measures to prevent access thereto or to limit its visibility. This intention can materialize in cyberspace through the utilization of the OSN's privacy tools. In other words, utilization of these privacy tools is the manifestation in cyber world of the user's invocation of his or her right to informational privacy. Vivaris versus St. Teresa College. Distinguish content-based regulation and content-neutral regulation. In content-based regulation, restriction is based on the subject matter of the utterance or speech, while content-neutral regulation it is merely concerned with the incidents of the speech, or one which merely controls the time, place, or manner of expression under well-defined standards. Content-based regulation bears a heavy presumption of invalidity and is measured against the clear and present danger rule. It will pass constitutional muster only if justified by compelling reason. And so, testing its validity, the court will apply strict scrutiny tests. Content-neutral regulation only needs substantial government interest is required for its validity. They are not subject to strictest form of judicial scrutiny, but an intermediate approach, something which is in the middle of rational basis test or strict scrutiny test. DOJ and NTC issued a warning if TV and radio stations play the Garci tape, their franchises would be revoked. Is it content-based regulation or content-neutral regulation? According to Supreme Court, it is a content-based regulation because the focus of the restraint is on the content of the expression. Chavez versus Gonzalez. Is the regulation as to the size of tarpaulin, where the expression is to be made, considered as content-based regulation or content-neutral? Supreme Court ruled that it is content-based. The form of expression is just as important as the information conveyed, that it forms part of the expression. Large tarpaulins, therefore, are not analogous to time and place. They are fundamentally part of expression protected under Article 3, Section 4 of the Constitution. Respondents cite the Constitution, laws, and jurisprudence to support their position that they had the power to regulate the tarpaulin. However, all of these provisions pertain to candidates and political parties. Petitioners are not candidates. Neither do they belong to any political party. Comelec does not have the authority to regulate the enjoyment of the preferred right to freedom of expression exercised by a non-candidate in this case. What is benevolent neutrality approach? The benevolent neutrality theory believes that accommodation of religion may be allowed, not to promote the government's favored form of religion, but to allow individuals and groups to exercise their religion without hindrance. The purpose of accommodation is to remove a burden on or facilitate the exercise of religious freedom. Estrada versus Escritor. What is right against self-incrimination? The kernel of the right is against not all compulsion but testimonial compulsion. The prohibition of compelling a man in criminal court to be a witness against himself is a prohibition of the use physical or moral compulsion to extort communications from him, not an exclusion of his body as evidence when it may be material. When is one considered under custodial investigation? Any questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his freedom of action in some significant way. It starts when the police investigation is no longer a general inquiry into an unresolved crime but has begun to focus on a particular suspect taken into custody by the police who starts the interrogation and propounds questions to the person to elicit incriminating statements. Is police lineup part of custodial investigation? Police lineup is not part of the custodial investigation, hence the right to counsel guaranteed by the Constitution cannot yet be invoked at this stage. This is because during a police lineup, the process has not yet shifted from the investigatory to the accusatory, and it is usually the witness or the complainant who is interrogated and who gives a statement in the course of the lineup. People versus Amistuzo. Should the right to counsel be made available during preliminary investigation? The right to counsel applies in certain pretrial proceedings that can be deemed critical stages in the criminal process. The preliminary investigation can be no different from the in-custody interrogations by the police. for a suspect who takes part in the preliminary investigation will be subjected to no less than the state's processes, oftentimes intimidating and relentless, or pursuing those who might be liable for criminal prosecution. People versus Bongking Ko. Is the person facing extradition proceedings allowed to post bail? Yes. In Government of Hong Kong versus Olalia, the Supreme Court ruled that the right to bail is granted by the Universal Declaration of Human Rights, of which the Philippines is a signatory. While not a treaty, its principles, including the right to bail, are recognized as customarily binding upon the members of the community. If the right to bail is granted to a deportee, there is no reason why the right should be deprived of the extradite. What are the requisites of double jeopardy? Valid complaint or information filed before competent court, valid plea, previous acquittal or conviction, or the case was dismissed or otherwise terminated without the express consent of the accused. What are the requisites for the validity of an administrative regulation? Its promulgation must be authorized by law. It must be within the scope of the authority given by the statute. It must be promulgated in accordance with the prescribed procedure. It must be reasonable. Are issuances of the JBC required to publish in office of the National Administrative Register? No, the publication requirement in the owner is confined to issuances of administrative agencies under the executive branch of the government. Since JBC is a body under the supervision of the Supreme Court, it is not covered by the publication requirement of the Administrative Code. Villanueva versus JBC. What are the requisites for the validity of administrative rule with penal sanction? A. The law itself must make a violation of the administrative regulation punishable. The law itself must impose and specify the penalty for violation of the regulation. The regulation must be published. What is the doctrine of primary jurisdiction or prior resort? The doctrine holds that if a case is such that its determination requires the expertise, specialized training, and knowledge of an administrative body, relief must first be obtained in an administrative proceeding before resort to the court is had, even if the matter may well be within the latter's proper jurisdiction. The objective of the doctrine of primary jurisdiction is to guide the court in determining whether it should refrain from exercising its jurisdiction until after an administrative agency has determined some question or some aspect of some question arising in the proceeding before the court. Nestle Philippines et al. Versus Uniwide Sales. What is the doctrine of exhaustion of administrative remedies? Under the doctrine of exhaustion of administrative remedies, a party must first avail of all administrative processes available before seeking the court's intervention. The administrative officer concerned must be given every opportunity to decide on the matter within his or her jurisdiction. Failing to exhaust administrative remedies affects the party's cause of action, as these remedies refer to a precedent condition which must be complied with prior to filing a case in court. Ongsuko versus Maliones. What is a petition to deny due course the certificate of candidacy, and on what ground? A verified petition seeking to deny due course or to cancel a certificate of candidacy may be filed by the person exclusively on the ground that any material representation contained therein as required under Section 74 hereof is false. The petition may be filed at any time not later than 25 days from the time of the filing of the certificate of candidacy and shall be decided after due notice and hearing, not later than 15 days before the election. Section 78 of OEC. What matters are materially misrepresented? Material matters are qualification for elective office like residency, age, citizenship, or any other legal qualifications necessary to run for local elective office, coupled with the showing that there was an intent to deceive the electorate. The candidate nickname does not pertain to his eligibility or qualification for office and cannot be considered a misrepresentation. Villafuerte versus Comelec. What is the effect if the certificate of candidacy is declared void for lack of material misrepresentation? A cancelled certificate of candidacy cannot give rise to a valid candidacy, much less valid votes. If one certificate is void ab initio, then there was never a candidate. Thus, the second placer candidate is deemed to have garnered the highest number of votes and is entitled to hold the corresponding elective position. Aratia versus Comelec.
By the way, make sure to hit that subscribe button if you are not already subscribed. And to fuel our channel, let those ads play. Thanks.
When can there be valid substitution? Section 77. Candidates in case of death, disqualification, or withdrawal of another. If after the last day for the filing of certificates of candidacy an official candidate of a registered or accredited political party dies, withdraws, or is disqualified for any cause, only a person belonging to and certified by the same political party may file a certificate of candidacy to replace the candidate who died, withdrew, or was disqualified. Please take note that considering that Section 77 requires that there be a candidate in order for substitution to take place, as well as the precept that a person without a valid COC is not considered as a candidate, it necessarily follows that if a person's COC had been denied due course, he cannot be validly substituted. Thus, the existence of a valid COC is a condition sine qua non for a disqualified candidate to be validly substituted. Talaga versus Comelec. How is petition for disqualification different from petition to deny due course, the COC? The disqualification case under Section 68 is hinged on either 1. A candidate's possession of a permanent resident status in a foreign country or his commission of certain acts of disqualification, that is, vote buying, terrorism, overspending, soliciting, or making prohibited contributions. If a candidate is disqualified, he technically is considered to have been considered a candidate. Denial of due course of COC is premised on person's misrepresentation of any of the material qualifications required for elective office aspired for.
Disclaimer: I give credit to the online source of this review material. No infringement is intended.